Welcome to the latest episode of Counsel. I'm here with my colleague, Caroline Jaques, and we are going to be talking about the new Virginia Wage Transparency Act, which goes into effect on July 1st of this year. It impacts all employers in the state of Virginia, no matter the size, no matter the industry. It prohibits employers from seeking wage and salary history information from prospective employees. And it makes it clear that employers cannot retaliate against an applicant for refusing to provide wage and salary history information. And it also requires that employers set a good faith wage and salary range on both internal and external job postings. So, Caroline, let's dig in here a little bit. What do employers need to be doing to make sure that they're in compliance with the new wage transparency law?
Thanks, Jamie. Yeah, this law marks a significant departure from established hiring practices, so it's definitely one to pay attention to. Employers cannot ask employees what they earned at their previous jobs. Further, they can't rely on an employee's wage or salary history to determine a wage or salary for a new position the applicant is interviewing for. One exception is when an applicant voluntarily discloses their salary history, an employer can confirm that and use that information to offer a higher wage or salary for the job. It's also unlawful for employers to retaliate against prospective employees who request information about a job's wage or salary, or ones that refuse to share their wage or salary history. Practically speaking, employers should review existing application materials to ensure that applications do not require applicants to disclose salary or wage history, and policy and guidance for interviewers should be updated to make sure that interviewers are not asking applicants for their compensation history. Can you tell us a little bit about the requirement to include salary ranges in the job postings?
Sure. I mentioned at the top that the wage or salary range needs to be set in good faith by the employer. There's some clues in the statute about the data that you can use to come up with a good faith range. That might include a previously determined wage or salary range for the position. It may include looking at the actual salaries of the people that are currently in equal positions or equivalent positions, or looking at the budgeted amounts available for the position. There's not a lot of legal guidance on what constitutes a good faith range, but generally speaking, the broader that range, the more likely it is that the employer may be opening themselves up to somebody questioning whether or not that range was created in good faith. So the practical implications of this are, again, that, both external and internal postings need to include a realistic wage or salary range. Keep a note in the file as to how that range was determined and the data that was used to create it. And to the extent you're working with any third parties like recruiters or agencies that are doing hiring work on your behalf, that their postings need to be sure to comply with the law. So Caroline, how is this law going to be enforced?
Yeah, the Attorney General can bring a civil action against employers who are not in compliance with the law. And if you violate the law by asking an applicant about their salary history, that person can also bring a lawsuit within 1 year of the violation. Further, if you fail to include the required salary range in a job posting, you have a cure period of 15 business days to correct the noncompliance.
So to recap, employers should not be asking prospective employees or applicants about their wage or salary history, not in an interview, not in an application. And then you want to make sure that there's a good faith wage and salary range included on all job postings. This law goes into effect on July 1st. If you have any questions about coming into compliance, please feel free to reach out to the Hirschler team, and we're happy to help. And thanks for watching this episode.